I am Gilda Daniels, an associate professor at the University of Baltimore School of Law. Okay. While we lost a part of the Voting Rights Act, certainly Section 5 was a very powerful tool that we have had for almost 50 years and required jurisdictions to provide information more so. And I think that's one of the things that we're missing more so than anything else from the Shelby County decision is that we don't get the notice that we used to get from the jurisdictions about the kinds of changes that they are making in regards to voting. So without that notice and without the federal government overseeing, if you will, how these changes are being made and making a determination whether or not these changes have a discriminatory impact or effect, it has been difficult, I think, for advocates and lawyers and even citizens to kind of adjust to the new terrain in voting rights. And there have been many challenges, right, brought by advocacy groups across the country to things like voter ID, more restrictive voter ID laws, limits in early voting, voter registration restrictions, and even some redistricting cases. So we've seen the gamut, essentially, because once the Supreme Court made the Shelby County decision finding that parts of it was unconstitutional, we saw that states responded almost immediately. States like Texas said that they would implement a voter ID law that a court had said was intentionally discriminatory. And you had states like Virginia, that was a previously Section 5 covered state, that said, you know, we're going to implement our restrictive voter ID law as well. And you had state after state, which was formally covered by Section 5, to say, now that we don't have to get the federal government's approval, we're going to do whatever we want to do in regards to voting rights, regardless of whether or not we know that it will adversely impact minorities, voters of color, elderly voters, women, and or students. And one could argue that it's with that intention that these laws have been passed, because there's a recent Washington Post article that actually said that it had a study that showed that where you had increased minority voter turnout is the states where you had an increase in these suppressive voter laws. So I don't think that's a coincidence. Discrimination still exists in voting, and the Supreme Court acknowledged that in its Shelby County decision. And it also acknowledged that we still have Section 2 of the Voting Rights Act, which is a nationwide prohibition against discrimination based on race, color, language. And it's still a very powerful tool that can be used, but it's very different from Section 5. With Section 2, the burden shifts. Now it is the voter that has to demonstrate that the change or the voting method, whether it's a redistricting or a voter ID law, is discriminatory. Under Section 5, it was the state or the jurisdiction that was passing the legislation that had to demonstrate that it was not a discriminatory law. Right? So now that you have these shifting burdens, while we still have Section 2, Section 5 allowed us to make these determinations faster, right? As well as having a notice requirement, you had a deterrent requirement as well, and it was less expensive. Now there are jurisdictions, certainly states were arguing that it was so expensive to have Section 5, but the expense was when you litigated the cases, not when you submitted them to the Attorney General for the United States. So while we still have Section 2, it is important that we have lawyers, who are trained in bringing these types of cases, because they are long and arduous and very expensive. A typical Section 2 case can cost between $500,000 and $2 million, or some recent costs for Section 2 cases. Well, I think the Voting Rights Amendment Act is a good start, and that's essentially been the talking point for most of the advocacy groups, right? That it's a good start, and it is a good start. But I had hoped that we would seize the moment and treat this more like a Charles Hamilton Houston moment, where it could be transformational, where we could think about what is it that we would like to have in a comprehensive voting rights law, right? And in establishing new triggers, right? The trigger that they have in the Voting Rights Amendment Act would only grab about 5 states, as opposed to the previous 11 to 16. There were in whole or in part. And states like Alabama are not included under the Voting Rights Amendment Act. States like Florida are not included in the Voting Rights Amendment Act. And so it still leaves a gulf in between what's needed and what's being proposed. Well, I think that's a question that you really can't answer in 5 minutes, but I would say that I think that we need to look to our history. And I think if we could look to our history of how we've dealt with voting in these United States of America, right? And even at this pivotal time where we have the Shelby decision, which has gutted a large part of the Voting Rights Act, it's very similar to what happened during Reconstruction, right? You pull the protections, the legal protections, and you got massive, voter suppression, right? And I'm afraid that can happen in this generation. But certainly I'm working to ensure that it does not, and there are others who are doing so as well. But I think if we look to history, we can see how it can certainly repeat itself if we feel that what the gains that have been made are enough, which is essentially what the Supreme Court has said. It's like you have more than 50% turnout, you have voter registration that's on par with blacks and whites, therefore we don't need Section 5 of the Voting Rights Act, and essentially said it's enough. You've made enough gains during these last 50 years to do away with these kinds of race-conscious remedies. And having the Supreme Court in its present configuration is a challenge, right? When there's very little recognition for equal protection claims as under the 14th and 15th Amendment. And we have to be more creative about how we fashion the narrative, how we talk about voting rights, how we put our cases together, where we file our cases, so that we can start regaining ground that's certainly been lost. And it's only been a year. And so the fact that we're all focusing on it and realizing that this is a big moment that continues, I think is encouraging. It is extremely important who sits on the court, whether it's the state court or the federal court. And every state is going through has gone through or will go through a primary season, and then we have the midterm elections where we typically have very low turnout. So certainly those of us who are concerned about not only the court but the legislature have to be more involved in the process, in the electoral process. We have to educate ourselves about who these candidates are, as well as what are the rules around how you get to vote, right? What are the voter ID rules in your state? Can you challenge those laws? How can you participate in the election process? Can you serve as an election judge? Because even after you get the voter ID, after you've registered, you still have issues about voter deception and voter challenges. And so inside the polling place, you also have concerns as well. So I think it's a multifaceted approach that we will have to take here going forward, and that while we're focusing on Shelby County and the case and all that it has meant and all that it means, the on the ground grassroots effort, I think, is something that we should focus on as well. We're about to celebrate 50 years of Freedom Summer, and having those reminders that voter registration is still very important and can change the way the judiciary looks, right? It can change the way the United States Senate looks. It can change the way the House of Representatives looks. If we can get folks registered and have them turn out, that can be a game changer.